A state can hand you a carry permit with one hand, then make that permit almost useless with the other. And right now, the biggest court fight over that trick has the Department of Justice and more than 24 states backing the people challenging it. Quick question before we keep going. Are you subscribed yet? Because this is exactly the kind of legal update most gun owners hear about too late. And when you hear it too late, you don't just lose an argument online. You can lose your rights, your money, and your freedom. So if you want simple, straight talk on gun law without the fluff, hit subscribe right now. I cover the stuff that actually changes what you can do in the real world, not just what people argue about in comment sections. Now, let me give you the most important truth up front. The final Supreme Court opinion in this case is not out yet, so don't let clickbait fool you. But here's why this is still a huge breaking story. The Supreme Court is reviewing a case called Wolford versus Lopez. It comes out of Hawaii. And the big question is simple. Can a state say your permit is valid, then make it a crime for you to carry in most places open to the public unless every property owner gives clear permission first? First thing, here's what just happened. After the Supreme Court's Bruen decision said the Second Amendment protects carrying a handgun in public for self-defense, Hawaii passed a new law. That law said, if you have a carry permit, you still cannot carry on private property open to the public unless the owner gives express permission. In plain English, that means clear permission, a sign, a verbal okay, something direct. Now, that sounds small at first, but here's the crazy part. Most stores do not put up signs saying, yes, licensed carriers are welcome. Most restaurants don't do that either. Most gas stations don't. Most shopping centers don't. So the rule turns silence into a ban. Think about what that means for your daily life. You leave home, you stop for coffee, you grab gas, you run into a pharmacy, you pick up dinner. Under a rule like this, your permit may still exist on paper, but the state has turned normal life into a minefield. And that is why people call this kind of move permit abuse. Not because the permit office clerk was rude, not because a form was too long, but because the government says, sure, you can get a permit, then writes the rules so your permit becomes a decoration. Here's a hypothetical example to explain this. Imagine you are fully licensed. You passed the background check, you paid the fee, you trained. You did everything the law asked. You walk into a small sandwich shop. There's no guns sign. There's also no sign saying carry is allowed. You think silence means you're fine. The state says silence means you're breaking the law. That is the trap. And here's what most people get wrong. This case is not really about forcing private business owners to allow guns. Property owners already have rights. If a store owner wants to say no guns, they can say no guns. The real issue is who gets to make that choice? The owner or the state? That is the whole game here. The challengers say the choice belongs to the property owner. Hawaii says the state can flip the default rule and presume guns are banned unless the owner opts in. Now, this is where it gets interesting. A lower court blocked parts of Hawaii's law, then the Ninth Circuit upheld most of the state's position. That set up the Supreme Court fight. So when people say this case could end permit office abuse, what they really mean is this. If the Supreme Court rejects Hawaii's trick, states will have a much harder time giving you a permit and then canceling its value everywhere that matters. Second, let me explain why the Department of Justice jumping in is such a big deal. The DOJ filed in support of the challengers, and the DOJ did not use soft language. It argued that Hawaii's rule, as applied to private property open to the public, is blatantly unconstitutional. That is strong language, very strong. The DOJ's basic point is easy to understand. States cannot get around Bruen by using indirect tricks. They cannot say, fine, you have a right to carry in public, but we are going to define almost every useful place as off limits unless someone posts a special welcome sign. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistake that turns a lawful carry stop into a bad police encounter in seconds. Subscribe so you don't miss it, because that one could save you from saying the wrong thing at the worst possible time. Third, here's the part nobody is talking about enough. This fight is also about history, because that's the test the Supreme Court has been using in major gun cases. Hawaii tried to defend its law by pointing to old rules and saying, look, history supports us. But the challengers, the DOJ, and the states backing them all say those old examples do not match what Hawaii is doing now. One of the most controversial examples was an 1865 Louisiana law, and this is the part that shocked me. The DOJ argued that law was an outlier tied to black codes. In simple terms, those were discriminatory laws used after the Civil War to control and disarm newly freed black Americans. The DOJ's point was blunt. A law with that kind of ugly purpose should not be used as proof that modern carry restrictions fit our constitutional tradition. That matters for one big reason. If courts can pull weak, odd, or openly discriminatory laws from the past and call them a match, then almost any gun restriction can be dressed up as historical, and once that happens, the history test stops protecting your rights. Fourth, there is another major point. More than 24 states, along with the Arizona legislature, also backed the challenge. Their argument was simple. Hawaii flipped the normal rule on its head. Traditionally, if a private property owner wanted to ban guns, the owner could say so. But the state did not get to treat every silent business like it had posted a ban. That sounds technical, but it changes everything. Most people live normal lives in places that are privately owned and open to the public: grocery stores, hardware stores, restaurants, strip malls, convenience stores. If the state can turn all of those into no-carry zones by default, then public carry becomes a right you almost never get to use. Have you ever wondered how a government can say it follows the Supreme Court while still crushing the right in practice? This is how. It doesn't always ban the right directly. It surrounds the right. It cuts off the roads leading to it. It leaves you with a right that exists in theory, but disappears the second you try to live your life. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And please hear me on this warning. Don't make the mistake of thinking this case means every location is open for carry. Even if Hawaii loses, property owners still keep their own rights. Sensitive place rules will still be fought over. State laws will still differ. The point here is narrower but still huge. A state should not be able to use your silence, or business owner's silence, as a weapon against your permit. Fifth, let me tell you what happened at oral argument, because this is where the temperature of the case really changed. During arguments, several justices sounded deeply skeptical of Hawaii's position. They pressed the state on whether this was really about property rights, or whether it was a workaround designed to make lawful public carry nearly impossible. That is the key question. Is Hawaii protecting owners, or is it hiding behind owners? Some of the justices seemed bothered by the idea that a state could reduce a constitutional right to second-class status. Others drilled into whether Hawaii was relying on bad historical comparisons. And that tells you something important. The court was not just asking, can a property owner say no? Everybody knows the answer to that. The court was asking whether the state can make no the automatic answer almost everywhere. Hey, 73% of people watching updates like this are not subscribed. Don't be part of that group. Join the gun owners who want the legal news before it blows up in their state. Hit subscribe right now, because this channel is built for people who care more about staying legal than sounding clever online. Sixth, let me break down what this could mean for you if the challengers win. Number one, it would send a message to every anti-carry state that permits cannot be turned into fake permission slips. Number two, it would strengthen the idea that the government cannot dodge Bruen through clever drafting. Number three, it could affect similar laws in places like California, New York, New Jersey, and Maryland, where lawmakers have also tested ways to choke off carry without saying the word ban. But wait, there's something even more important. A ruling in this case could shape how courts look at future gun laws. Not just carry laws, future laws. Because if the Supreme Court says clearly that governments cannot use outlier history, cannot flip long-standing defaults, and cannot make rights useless through indirect burdens, that reasoning can spill over into other cases. Now let's talk real-world consequences. Imagine you travel. Imagine you cross state lines. Imagine you're trying hard to follow every rule. The worst kind of gun law is not always the loudest one. Sometimes it is the confusing one, the one that lets you think you are okay right until you are not. That is why this case matters so much. It is about notice, fairness, and whether normal people can actually understand the line between lawful carry and criminal conduct. Most people think the biggest threat is an outright ban, but the truth is often more slippery. The real threat is the law that leaves you guessing. The law that turns ordinary places into danger zones for licensed, law-abiding citizens. The law that says yes at the permit counter and no everywhere else. And if Hawaii loses, other states will not just give up. They will rewrite. They will repackage. They will test new language. That is why staying informed matters. One court win does not end the fight. It just changes the next battlefield. So what should you do right now? First, know your own state law code. Second, if you travel, study the law before you go, not after. Third, do not assume a permit means universal carry. It never has. Fourth, watch this case closely, because the final ruling could land soon and could have nationwide ripple effects. This information could become even more important the moment the court drops its final opinion. Subscribe now, because when that ruling hits, I'm going to break down exactly what changed, what did not change, and what you need to do next so you do not get caught behind the curve. Here's the bottom line. Wolford v. Lopez is about whether the government can make your carry permit meaningless by banning carry in most places, open to the public, unless businesses post special permission. The DOJ says no. More than 24 states say no. And based on the questions at oral argument, several justices seem very uneasy with Hawaii's rule. So stay sharp, stay calm, and stay informed. If you want legal updates explained in plain English, subscribe and turn on notifications, because the worst time to learn a gun law changed is after you already crossed the line. And one final reminder, this video is for education only, not personal legal advice. Laws change fast, facts matter, and your best move is always to check your local law and talk to a qualified attorney about your specific situation.